All right, welcome to the People Show. This is Mark Wallace, your host and facilitator. We're having some issues tonight. I'm not sure what that is, but hopefully we'll get it under control. So if you are trying to get us, um, I don't know how I can get it to you, but certainly if you can't get us on Twitter, go over to one of our other channels, because we're on Instagram, Facebook, YouTube, and X, formerly known as Twitter. But I saw that there were some technical issues there, so hopefully we will do. So, of course, this is our Tuesday night legal hour, and my guest is the Cook County Circuit Court Judge Leonard Murray, who's going to be joining us momentarily. And we are going to be taking all of your legal questions. And of course, the judge cannot give you legal advice, but he can certainly answer your legal questions. So what I would ask you to do is to type your question in the chat, or your questions in the chat, and I'll read them off to the judge, and he will read off your questions. We're going to be talking about several things tonight. Two things that we're going to talk about. We're going to talk about condo assessments. When you purchase a property, many people don't know, or most people don't know, that when you purchase a condominium or a townhome that has a condo association with it, where you have to pay monthly dues, when you purchase a property, there may be delinquent assessments, and you are required to pay a certain amount of the delinquent assessments. Most people don't know what that amount is, or what that monthly allotment is. So we're going to talk about that tonight, and we're going to find out what the legal requirement, what your legal requirement is. We're going to clear that up tonight, so we're going to be talking about that with the judge when we come on. The other thing we're going to be talking about, we're going to talk about Bob Menendez, who is a United States Senator. Bob Menendez was convicted earlier today by a federal jury, and he was found, Senator Bob Menendez found guilty in corruption trial. He is seeking re-election to the Senate as an independent, although the guilty verdict quickly raises the prospect of an expulsion vote. Senator Bob Menendez on Tuesday was found guilty in his corruption trial, a historic verdict marking a dramatic downfall for New Jersey's senior senator, who was one of the most influential people in Washington, D.C. The 12-member jury found Menendez guilty on all 16 counts after a 2-month trial on charges that all but ended his political career. Federal prosecutors accused Menendez of bribery, acting as a foreign agent for Egypt, obstruction of justice, extortion, and conspiring to commit those crimes. So Bob Menendez, the senator from New Jersey, was convicted on all of those 16 counts. Bob Menendez's wife, I believe, is on her trial is going to be coming up soon, and to see if she has the identical charges or if she has different charges. But it's very interesting. So we're going to be having an interesting conversation about that, and about those two issues and any other legal issues or questions that you may have. Again, type them in the chat, and I'll read those questions off to the judge, and he will answer your questions. Joining me now is our weekly guest, the Circuit Court, Cook County Circuit Court Judge Leonard Murray. Welcome to the program, Judge Murray. How you doing?
Good afternoon, Mark. I'm doing well. How are you?
I'm doing fantastic. It's been a very busy legal cycle in the last couple of days, starting with Donald Trump down in Florida. Um, Judge Aileen Cannon dismissed the indictment on Donald Trump down in Florida based on technicalities, not on the merits, but or any evidentiary part of the case. But she dismissed that case based on um, an argument that 8 other federal courts have rejected that the special counsel um, has to be appointed by Congress, and that the Department of Justice, the Attorney General, doesn't have the authority to appoint a special counsel to the case. Of course, it's going to be appealed. What are your thoughts?
Excuse me. Well, that's curious because, in the Supreme Court opinion that was handed down now, I guess maybe 2 weeks ago now, or maybe a little less, regarding, I call it presidential immunity. Even though that was not an issue in the case, Clarence Thomas, in his supporting, special concurring opinion, uh, suggested uh, that the special counsel appointment in that situation was not valid because Congress didn't do it, and the statute apparently that was utilized to support it, in fact, doesn't grant that authority. In fact, I think Thomas suggested that statute had sunset. So therefore, it was no longer one that could be relied on to make that appointment. So it seems as if the judge in Florida picked up on Thomas's comments in that opinion and used it to deem that the indictment wasn't valid because it was brought by a person who was improperly appointed.
Yeah, he basically handed her, you know, uh, I guess a lifeline, or dangled her, the opportunity to use that, even though that was never raised in any of the arguments put before the Supreme Court, that he would make the kind of jump to that. And I believe that was, in my opinion, and I think in a lot of other people's opinions, what his um, purpose was to hand that to, um, in this case, Judge Aileen Cannon to utilize, and that's what she did.
Well, but that does not prevent the Attorney General in this general broader scope of authority from bringing that indictment.
Correct.
Um, she's suggesting that the special counsel appointed was without power. Um, so, so it's not on the merits as you have stated. Uh, in fact, I'm not even sure I would suggest this on a technicality. It's just that she's suggesting that the person who filed the indictment didn't have authority to do it. So it was invalid from the onset. Um,
Well, if that's the
but
case, if that's the case, then the special counsel that has been appointed to try and have charged Hunter Biden is invalid.
yes, sir, that would likewise be the case. And I suppose it would also be the case with uh, the case that the Supreme Court decided, because that was being litigated by special counsel, but they didn't touch that issue. And
Mhm.
I tell folks all the time, one of the place to start with most litigation is not the opinion. You need to see what the arguments that were raised in the briefs covered, because I gotta believe that if that issue had been raised uh, by Trump's lawyers in the brief that they filed in the Supreme Court, they would have weighed in on it. So either it was not raised. So it's curious that Thomas kind of went outside of the briefs and picked up that issue when it was not part of what was before the court.
Almost as though he was acting as a surrogate attorney, bringing up an argument for the former president.
Yeah, you have to wonder about that, but Supreme Court members, you're not limited to what the parties raise in terms of the case itself, cases that they cite, arguments they make, and so forth. But to go outside what the issues are raised on appeal, normally in the appellate process, uh, the appellate is required to set forth a statement of the issues on appeal, and that directs the court as to what is to be considered by each side, the proponent and respondent, uh, in terms of their arguments. But here's a situation where apparently Trump's lawyers did not raise it in their briefing before the Supreme Court, I suppose. And I'm now going to go back and try to see if I can find those briefs online to see if it was raised at all. But I can't believe if it was raised that it would not have been covered in terms of the opinion.
Yeah, I don't think that it was raised. I think every report indicates that it was never raised, and they made a real point of Clarence Thomas addressing something that was never argued or never raised by any of the attorneys.
And he's done that in a number of situations, which I cannot bring to mind to direct the audience to right at this moment. But that's not the first time that he has done that. In fact, he suggested in some of his concurring, I guess, opinion outside of what the main majority comments on, that there are issues that he believes are ripe for decision by the court, and in fact, erasing or reversing precedent that's already out there. So they always talk about activist judges. You might argue that that's what he's doing in this situation. He's an activist because he's going outside the scope of the briefs and also the issues raised on appeal.
Yeah, I don't think that. Well, I think in a lot of people's opinion, legal scholars who have, across the spectrum, have said that the Supreme Court over the last, certainly the last 20 years, have become far more involved as a legislative body rather than as a balls and strike judiciary that keeps both sides in check. That it has become a court where that has become far more active.
Yeah, they're making policy.
Yeah,
They're not. At least that's the argument.
Yes.
They're not determining whether the cases brought before us, based on congressional act or even state actions, in fact, are constitutional. They seem to be suggesting what the Constitution is, and maybe bending the document to some extent in order to make it compliant with what they believe the rules should be.
Yeah, I'm not sure how we rein that court back in, or if it even happens in our lifetime, with the makeup of the court and for the people on the court. Obviously, there's a few people on the court that would be looking to retire. Certainly, if Donald Trump was reelected, there certainly are two that will be stepping down, so that he would have two more nominees to the bench. I don't know that any president has had that many nominees to the federal bench. Not to mention that there are 40 46 or 47 other federal lifetime appointments that the next president is going to um, have at their disposal. So uh, uh, the judiciary is on the ballot. It is on the ballot as well as democracy is in this November election.
Well, it's I'm not sure whether the complexion of the court, its composition at least, was a burning issue with Trump when he ran in 2016. I think it was really Mitch McConnell's vision in terms of what could be done with the Republican president. I wouldn't necessarily think that Trump really had a sense for what was possible given the power of appointment.
No,
And
that's why they want Donald Trump, is because people like Mitch McConnell and those Republicans know that they have the power to control and the power to do exactly what it is they want to do, and he'll just sign off on it. That's why they want him.
right, but
Now, this
now
is clearly Mitch McConnell's court.
right now, of course, McConnell, I think is. I guess he is retiring as the minority leader in the Senate.
Yes.
So I don't know whoever will replace him if they will still have that same gusto for that issue or not. But certainly it's an important issue, and somebody will be pushing it. Maybe not in the Senate as such, but certainly in the political world. There are a number of organizations that really focus on composition of the federal courts in terms of trying to push whatever their policy beliefs are.
Yeah. Well, it remains to be seen. Another thing that happened that is a very interesting case. Bob Menendez, the senator out of New Jersey, was found guilty today on all 16 of his corruption cases, that he was acting as a foreign agent. And he was found guilty after a 2-month trial, found guilty on all 16 counts. Now, the very interesting thing here is he is a sitting senator, and even though he is a convicted felon of 16 counts, it does not preclude him from holding office or running for election. The only way that, aside from him resigning from office, is that he would have to be expelled by a 2/3 majority vote in the Senate. But it does not preclude him from running for office.
No, that's correct, or continuing to maintain his current office. But
was that intended by the founders?
Well, no, that's not in the Constitution. And you're asking a question about what was the dialogue during the drafting of that document. But of course, we have these 3 co-equal branches of government, and each of them are self-regulating in terms of their operations and conduct. That's one of the big issues confronting the U.S. Supreme Court now, in that some of the things that have been alleged in terms of loans and gifts and so forth that Clarence Thomas has received, does it create a conflict? Is it ethical violation? And then there was one situation where it was strongly suggested that he should have recused himself in a case where I think he was the authoring justice that dealt with the healthcare industry because of what was initially a loan from an executive of a healthcare agency, which ultimately turned out to be a gift. And one of the points that's been raised by, I think, a member of Congress, the House of Representatives, is whether or not that gift should have been reported as income on his federal tax return. I think my memory is correct on this, less than $250,000. Uh, and it was a loan forgiven, and typically loans that are forgiven have income tax consequence. So the point is whether or not he properly reported that transaction on his personal income tax return. And you may well have also heard about this trip to Russia that apparently is on the table in terms of his activities while on recess. And I still don't quite understand what that's about, but I heard that that is also of concern to many who are in the political world.
Yeah, I am, I guess like a lot of people raising questions, why would anybody be investing that much money to give gifts to Supreme Court justices? Uh, they're not doing this just to be that they think that the Supreme Court justices are, people who are deserving of this and they just want to be generous. Nobody does that. It's
Yeah, it's yeah, it is interesting. You know, how is it that first of all, how is it that they came to be that
right.
they came to realize um, that he wanted to buy this? I think it's a mobile home. Uh, in order to purchase it, he didn't have the resources, personal resources, and the cost for the transaction was more than $250,000. You know, how is it that that knowledge filtered over to this person who is a healthcare executive?
Yeah.
So all that is interesting. The situation where I think it's where his mother lives, and Republican donor not only bought her house that she lives in, but also property around it. So she has this perimeter of safety, if you will, because of that. It's just I don't know who else does that. Um, so it's just very curious.
Yeah, it's very, very curious and certainly very, very compromising in that case. But going back to this Bob Menendez, I guess that also raises the question: how did this come that here it is, a person who is a federally elected senator is now convicted of 16, 16 counts, just a convicted felon, and could actually hold office unless that branch votes to expel him with a 2/3 majority. But it does not present him or prevent him from running for office because he's running as an independent. But it doesn't prevent him from running for office when you have people who have been convicted in around the country in different states of state crimes that lose their right to vote, or people who are incarcerated that lose their right to vote. I would think that this would be a constitutional argument that somebody can bring, like the ACLU, they could bring this argument before the Supreme Court and say, hey, here's a precedent. If a person on a elected to a federal office can be convicted of a crime, or a person can be convicted of state crime, can still run for the presidency of the United States of America, then every other person should have their inalienable right to vote, regardless of whether they're convicted for a crime or not, which is what my belief is anyway.
Well, there's nothing that prevents, in terms of statute, that prevents Menendez from holding office, continuing to hold office, and/or running for reelection. I don't know if this is a reelection cycle for him,
It is.
uh, but the power is in the ballot box. The voters of New Jersey, if they are so in love with him to believe that They want him to continue to be their senator. I don't know what kind of race is involved there, if he's got a challenger. And then also, it has consequences in the Senate, because I think right now the Democrats have a two-seat majority, as I
Yes,
remember.
yes,
Um, it's razor thin, Democratic majority in the Senate, and likewise the Republican majority in the House. Both places they're razor thin. So the consequence of Menendez's conviction, and as you probably know, this is the second time he's been tried
right.
for corruption charges. I believe, he was found not guilty in the first case.
It was a hung jury in the
It was
first case.
hung, and the feds decided not to prosecute again,
Yes,
because that's not this is not the same facts.
right.
Okay. All right. So they declined to prosecute again in that first case. So therefore, you can't really argue that he's a felon. But here you do have that argument, and I believe the Senate, um, on the two-thirds vote that you mentioned, they would have the right to expel him. Um, uh, so it may well be that there may be movement to that effect. I'm sure Republicans would want to do that because it will bolster their ability to regain control of the Senate. Um, but I don't know
Yeah,
if
well, I think that it's certainly consequential there, and um, we'll see how that happens because there's also a time factor, right?
yeah,
Because the election is 113 days away. That
yeah,
there's a time factor there, and the question becomes how quickly are they able to exercise this vote? And the governor of New Jersey uh, um, appoints someone to that seat, or even what the rules are to that, because again, his seat is on the ballot in November. So they would have to do some political gymnastics, quite quickly.
yeah. And I've got to believe, given his vulnerability, which this indictment, I'm sure, uh, was public, such that the Republicans could have mounted a primary and then have a winner in that contest. So there's no doubt a Republican challenger on the ballot. So now the Democrats may well have to, uh, as you say, engage in some political gymnastics in order to come forward with someone or try to convince them not to run. Just for the good of the party uh, uh, argument, and see if they can come up with another viable candidate. But all of this is going to be very tough. But you're right. He's got a right to run under law, and but for ejectment by the Senate, he can sit.
Well, do you think that as a result of these cases, including the cases against the former president, where he's indicted on two cases, one has just been dismissed, that will be appealed and probably overturned, um, and is also convicted on state charges? Do you see this as becoming a precedent for allowing for people, not necessarily who would be running for office, but certainly allowing for every other person who is eligible, whether they're convicted of a crime or not? Do you see an argument there that this is a precedent that can be argued before the Supreme Court.
In
Because I
terms of
mean,
voter rights,
yes,
uh, well, the federal conviction of Menendez does not take away his right to vote. Uh,
exactly.
uh, and it's state by state. I mean, there's some states that even after conviction, service of your sentence, uh, you're still not restored to the right to vote.
Well, in the state
Um,
of Florida, you cannot you cannot vote if you're
right.
convicted of a crime
Yes.
in Florida, and you cannot vote. They just expanded that that you cannot vote until all of your restitution is paid,
Right.
is
Um,
settled. So then, why does that not apply to the former president?
but that's the voting really, and I know we look at these national elections, but voting is really state by state.
Hmm.
Uh, for example, as you probably aware in Illinois, if you've been convicted of a crime, you cannot run for public office. Uh, Even after you have served your sentence and been restored to voting rights in Illinois, you cannot run for public office.
Is it that
Uh,
you cannot run for public office, or you cannot hold public office?
you cannot hold public office. But the argument is that sure, you can be on a ballot, but then you can't serve in a position because it is prohibition against con- folks convicted of crimes holding public positions. Uh,
How did the mayor of Markham win his case? Who was a convicted felon, served his time, and eventually won his argument to take his seat, and he's the mayor of of Markham. What happened in that case?
I, I know the case, but I'm not sure the particulars as to why he was allowed to maintain that seat, even though having the background that you mentioned. So maybe that's something to look up for next week's program. But I'm not sure why, in that situation, he was not prohibited from holding the office. It may have well have been um, the issue raised and how the challenge was presented. Both before the electoral board uh, that was in place, and then secondly, what was presented in court, because the court can only review uh, what was presented uh, before the electoral board as a challenge. So I'll have to look at that. I heard about it, but it was never clear to me because I didn't read the cases or review the administrative process
Mhm.
involved to determine why he was successful in that situation.
Yeah, we never. I was trying to look up the article um, to see if we could get some background on it, but that would be um, that that would be a very interesting case to look at it from the legal perspective of how that happened. So it says that Illinois State Supreme Court has ruled that the mayor of Markham, a convicted felon, should be allowed to keep his job. So what does this mean for other ex-cons with friends in high places? This says. So if 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 the Supreme Court, the Illinois Supreme Court, says that this person can keep his job, shouldn't that open the door for anybody else who has been convicted of a crime to
You
run for
would think
public office?
you would think so, but I think we have to read the opinion to see what the basis, the rationale
Okay,
that was expressed there.
okay.
I have not read the opinion, so it is curious given, uh, and also it's important to remember that the local governments is the body that enacts the the uh, the rules relative to holding of office within their political divisions.
Mhm.
So that it depends on what Markham's ordinance provided for, because there is no statewide law on a prohibition against a felon holding public office. It's it's government, local government by local government.
So it flies under the home rule.
Yes, yeah, yeah. Illinois is a home rule state, so
Mhm.
we have all these various political divisions who enact uh, uh, rules governing how you conduct yourself within their boundaries. For example, speed limits, setback requirements, curfew, um, uh, you know, how many people can occupy a certain space at a certain time. All these things are subject to local government.
All right, well, that's going to be our homework for next week. So, folks, next week we're going to dive into the case from where the current mayor of Markham, who was a convicted felon, was able to keep his seat. So, we're going to find out how that happened. Because certainly they tried to, in Markham, they tried to prevent him from holding his seat. So we'll find out more about that coming up on next week's program. I want to turn to assessments, condo assessments, where somebody buys a condo and um, there are delinquent assessments. Now there has been a point of contention here, I know, on a number of issues here. I'm a property investor, and I have bought, a number of properties that have delinquent assessments on them, and there is this rule in place. I don't even know. I've never even investigated. I don't know if it's a law, or if it's a rule, or if it's, you know, um, a, by based on from association to association. So, what is the rule, or what is the law as it relates to purchasing a property that has delinquent condo assessments? Um, it is it is said that it is 6 months that you have to pay if you're the incoming purchaser and there's delinquent assessments. You have to pay 6 months of the previous delinquents from the time that you purchased the property. Is there a law? Is there a rule? What's the situation?
That's law, uh, and the reason it came about uh, really does not relate to typical across the closing table transaction. It came about because a lot of the mortgagees, when they foreclose on these properties, would would delay taking title because until they took title, they were not obligated to pay the assessments. So, in order to prevent the mortgagees, and when I say mortgagees, of course, I hope folks most realize that's the mortgage company. That's
Right.
who was the lender. Uh, uh, that they were sitting on their right to take title because upon taking title, then arises the obligation to pay assessments. So, in order to combat that practice, and this goes back to the height of the foreclosure crisis, back now, gee, I guess what 15 years ago, 16 years ago, like
Yes.
2008, nine in that era, uh,
Mhm.
where and it's a little known fact that Cook County had the highest number of foreclosures in the country,
Mm.
at the highest foreclosure rate in the country. And
Right.
it's a dirty little secret that's out there. So these mortgage companies, with all these foreclosed properties, in order to avoid that liability, would sit on their deeds. meaning sit on the right to request the deed, issuance of the deed, because upon uh, that request arises the obligation to pay assessments.
So, if it is law, what is the law for someone who purchases a property? Are they required to pay the previous 6 months from the date or the month that they took ownership, or that they were under contract?
Well, your rights and obligations don't arise until you take title, and part of the closing set, if you will, is a request of a letter to the condo management asking for status of assessments. So as part of the closing transaction, you can make sure that the seller is in fact paying, making current the status of the assessments, uh, or not, if that's a fact that you're aware of, and hopefully you have factored that into your purchase price.
Right.
Uh, but it is uh, it's part of the deal, and in that situation, when you take title, uh, that that date is when you become obligated to be responsible for the assessments. Assessments are a lien
Right.
against the condominium itself. And most notably, most associations don't enforce their rights as a lien holder. They typically will file an eviction action uh, based on delinquent assessments. They will take possession by virtue of a court order granting them possession. Usually, in the condo cases, there's a certain stay period. I think it's 60 days. I may be a little rusty there. I haven't sat in landlord-tenant court in, gee, you can believe it, 10 years now. Um, so I believe it's a 60-day stay, so that the condo association's right to take possession is stayed for, I believe, 60 days. I could be wrong on that number. It's something I'll have to update the audience on next week as well. Um, but if there is a tenant in the unit, then it gives the association the right to receive those rental payments directly, rather than trying to uh, force the landlord, I'm sorry, not landlord, but the condo owner from transferring that money over. So you can directly go to the tenant. There's a order, and I'm trying to think of the phrase that's used now to describe it, that would direct the tenant to pay his or her rental payments to the association. And until such time as the arrearage is cured, the association would continue to have the right to receive those monthly rental payments. Now, should the tenant fail to, or refuse at least, to abide by uh, uh, that directive, then the association could enforce the possession order against the owner of the property and its tenant, if that's the situation.
Well, well, the question that was raised, um, and it brought about another question, that from the day that you take title, okay, and it's clear that it's 6 months. That's what the law says, that you're required to pay the previous 6 months from the day that you take title. How does that impact someone who goes to a judicial auction and you win a bid at a judicial auction, but you don't get title at a judicial auction? You only get title once the court has fully adjudicated and approved the sale and says that the selling officer can now issue that person a deed. Does the date of responsibility take place the same when they take title to the property, or that they have been the successful bidder and you now have a what is called a certificate of sale. You don't have a deed, you have a certificate of sale, which
Yeah.
in effect says that you're under contract.
Yeah, well, essentially, that's something you turn in to the selling officer and say, "Give me my deed." Um, but it's the same situation as foreclosed property, uh, where uh, that 6 month look back period, if you will, uh, requires that the subsequent purchaser is responsible for taxes going back 6 months. Now, actually, there's a cutoff there because if you can imagine in most distressed property situations, that that condo owner may well have not paid assessments for more than just 6 months. So to
Right.
some extent, it's a cutoff or cap on responsibility for delinquent assessments. But at the same time, it places a burden on at least a mortgagee to not try to sit on its rights by virtue of foreclosure, uh, because that look back period then covers them to pay for that period of assessments. And it was really a measure to try to keep condo associations from going underwater. If they were bereft with multiple um, short sales or foreclosures or
Mhm.
whatnot,
Right.
um, where the transaction does not obligate anybody to pay assessments up in full, then they would go underwater, and it would really sink the entire development because of that. Um, and some folks may not appreciate the fact that the development is running your living unit is communal living. You cast your fate with maybe some folks you have never even seen before, but you're relying on them to make good on their promise to pay assessments so that the overall health of the development can be maintained.
Mhm.
But when you have a situation where you've got a significant uh, cadre of delinquent property owners in a condo situation, it can be very, very disastrous. I have a case now that involves a fairly large development, um, and they're in bankruptcy court because of some of the debts that have been accumulated over time. I believe some of their problem really is mismanagement by past boards.
Mhm.
But they're in a very, very difficult situation relative to trying to maintain their individual ownership of their condominium units. It may well be that um, it could be a forced conversion of the condominium unit if they don't come up with a viable way to get out of it, or they may vote voluntarily to do it themselves, which means they have to secure a certain requisite percentage of the owners in order who vote yes to deconvert. I think it's 85%, if my memory is correct. That's a significant percentage of ownership to try to obtain consent for deconversion.
All right, we have a question here, but I want to make sure that I'm clear on the question of when the time starts as a person who buys a property at a sheriff's sale or a judicial sale. So does it start from the time that you win the auction, or does it start from the time that you take ownership?
I think I think it will start from the moment it can be argued that you got an equitable ownership in this property. And uh, the example I gave is where a mortgage company, because of just the volume of properties that are delinquent, and they're taking back, that they might attempt to sit on their rights and not uh, take quote unquote title, because then arises the obligation to pay assessments. So uh, they may put that out. So now you get a situation where the prior owner is still in the unit, not contributing, and you've got the condominium, so I'm sorry, you've got the mortgage company which is now the owner, they're not contributing because they haven't taken the deed yet. So it's a calamity that really can hurt.
You mean they haven't taken the deed because they haven't foreclosed, or they just haven't
No,
recorded the deed?
they haven't they haven't turned in certificate
Mhm,
to have the deed issued because they're sitting on those rights.
mhm. And how can they do that?
Well, there's nothing in the statute that requires that they take the deed within any specified period of time. And that's why that 6 month period was enacted in order to provide somewhat of a security blanket for the condominium developments.
Mhm. Okay, all right. All right, well, we're gonna see, because there is a situation. We'll see how that argues, because it is being argued that um, the association is arguing that this individual, um, because they purchased the property at the sale, and that really doesn't it doesn't say that you have an equitable interest. It just says that you have a certificate to have an
And
equitable
not just
interest,
not,
right?
right, not just basically being on a successful bidder,
Right.
because the sale has to be confirmed.
It has to be
Uh,
confirmed by a
so the
court.
court, yeah, so the court might say, well, we're not going to confirm the sale because whatever the reason.
Right.
Once it's confirmed, then the selling agent uh, uh, would be presented with that certificate of sale, which would then require that they issue the deed. So I really think that uh, confirmation probably is the date which triggers the 6 month period,
Okay.
because then
Okay.
you certainly have an equitable interest in the property upon confirmation.
Right. We'll see. They plan on fighting this, so we'll see how that, because there's a dispute there. They're saying that they have equitable interest because they won the the bid at the auction, and the other is saying, no, it was confirmed by the court on a certain date, and that's the date that the judicial company or selling agent was authorized by the court to issue a deed.
Yeah, and confirmation triggers some other things. For example, proceeds of the sale. So
Right.
until the confirmation, until the sale is confirmed, the mortgagee is not going to receive compensation.
Correct.
So they have an incentive to go forward and confirm it as quickly as they can, uh, because that triggers the issuance of a check to them.
Right. 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 All right. It's going to be an interesting argument. Okay. We have Felicia Word, I believe it is. She says that if you own your condo, how many months are you allowed to be behind, 2 or 3 months before the HOA puts you in collection or file a lien?
Okay, so I know most people have not, but it'd be a very good idea for you to read the condominium declaration. And then secondly, the bylaws and rules that govern how you conduct yourself relative to your um, ownership interest in the condominium. That document may suggest what that period of time is, but it probably does not. But technically, and if it does not, uh, failure to pay 1 month is a delinquency. So in theory, unless the condominium board has adopted some policy relative to when they will take action, it may not be clear. Uh, because it's an action that must be brought by a lawyer, and the cost to file those actions now, I think, is somewhere around $400. Plus, there's a notice period. You do have a notice period with delinquent assessments. So you do have some time to try to catch up before a case ensues. But you really have to take a look at your declaration and your rules and bylaws to determine whether there is policy that's been enacted by the board, your condominium board, relative to how promptly, or how quickly, I should say, they will seek to uh, enforce the right of either eviction based on failure to pay, or file a lien or unpaid assessments. The mere filing of the lien in and of itself um, doesn't put you at risk or peril. Um, the lien can be foreclosed on, but that's a more lengthy process than going for possession. And in most instances, the association will seek possession rather than trying to foreclose.
Okay. All right, Felicia. So there's your answer. Make sure that you go and read your condo bylaws. And you're right. Most people don't read their bylaws, and it varies from association to association.
Yeah, there is no standardized set of bylaws out there in the world. Everyone is particular to who drafted it, the situation, the type of development. So it's a custom drafted document. And
All right.
it's like the insurance policy we talked about last week. Nobody reads their insurance policies.
Right. Right. Yeah. You don't know what your coverage is until you start to file a claim and realize that there are certain things are not covered, or if they're covered, they're only covered to a certain amount.
Yeah.
Yes. I remember someone who had an insurance policy, and they went to file a lien, and there was sewage backup. Sewage backed up all over and just destroyed their unit. And in their insurance declaration, clearly marked in bold language that they do not cover for sewage backup in the policy. And they were stuck. Now, they were able to, I don't know if they prevailed, but they were able to find out that it was not due to their own fault. I think that they tried to open take in action against the landlord because they had complained to the landlord before, and only to find out that there was a collapsed drain pipe that the landlord had eventually corrected. But so they have this action in the case.
Yeah, so that might not be considered a backup
Mhm.
in that situation because it was due to failure of maintenance.
Right.
Yeah.
Okay, Felicia Ward said she purchased her condo and she paid the back HOAs. She believes it was 3 to 6 months behind. I know that 6 months is a hard 6 months. The argument in this one case is, when does the clock start? Does it start at the time that I purchase the certificate, he says, or does it start at the time that the judge gives me ownership of it? Because if you purchase it, if you win the bid, you can't go to the property and go in that property.
Right.
Right? You can't go in that property because you have no rights to it.
You have no rights.
Yeah.
Yes.
So,
Yeah.
all right. Well, listen.
You would be a trespasser.
Absolutely. Okay, we're going to see how that shakes out in court. All right, look, that's going to do it for us this week, folks. Thank you all for tuning in to the program. Next week, we will answer that question. We're going to write it down and make sure that we come back to you and bring you that answer related to the convicted felon who is now a mayor of Markham. and how and why that is. So we'll answer that question, and then we'll take all of your questions that you may have. So stay tuned for us to be back next week for another edition of the People Show's Legal Hour with Cook County Circuit Court Judge Leonard Murray. Thank you all for being here with us. We'll see you next week.